Hello.
Can you hear me?
Hi, Rebecca. Yes.
Can you hear me?
Yes.
Okay. I just wanted to be sure of that.
Yeah, we can hear you.
Okay.
Yeah. Thank you.
Hi, Rebecca. Yes. Can you hear me?
Yes.
Hi.
Hi, Rebecca.
Hi.
Can you hear me? Hi.
Yeah.
Hi. Can you hear me? Yeah. Nitika, can you hear me?
Yes, I can hear you.
Okay. Okay. Yeah. Rebecca, I think we just have a minute. We'll start in about a minute. Yeah.
Oh, sure, sure, sure.
Hi, Anoop. Can you hear me now?
Yeah, I can.
Okay.
So this is the first time we're doing this, so we're just getting our bearings right with all the security settings in the university network.
Doesn't permit you? Zoom?
Yeah, I think the university has chosen otherwise. So getting on Zoom.
Yeah.
Right. So we've hit 5:30, so we'll start. So welcome everyone to this event on discussing 40 years of death penalty sentencing and the legacy of Bachan Singh and what it is. Thank you, Rebecca, for joining us. I know these are awkward and difficult times, and thank you so much for agreeing to do this with us today. What we'll do today is there's like a twofold agenda, if I may say so. One is that we've just released a report looking at 16 years of death penalty sentencing in trial courts in Madhya Pradesh, Maharashtra, and Delhi from 2000 to 2015. And a small section of this interaction is going to be about looking at those findings. In that sense, my colleague Nitika, who led the sentencing project, will speak about that for about 10 minutes. And then we'll have Rebecca give her own responses to the report for a bit, for about another 10 minutes. And then I'll have a conversation with Rebecca for 45 minutes on Bachan Singh and connecting it to the findings in the report of death penalty sentencing more broadly, looking at what has happened in the recent cases, especially in the Delhi gang rape case and the executions of the 4 men in March. And we'll traverse that breadth of issues, connecting issues in the report and issues of contemporary death penalty practice. But before we get into that, and after the conversation, my colleague Preeti will give her own reflections on the conversation just for 5 minutes, and then we'll have a Q&A for 20 minutes at the end of the session. And before that, I mean, I just want to briefly introduce Project 39A. We are a criminal justice program at National Law University, Delhi. In our previous avatar, we were the Center on the Death Penalty. And as the name suggests, we were only about the death penalty. And it's been about 3 years now where we have started looking at much broader questions of criminal justice. And we transitioned into Project 39A in 2018 to look at questions of forensics, sentencing, mental health and criminal law, torture, and legal aid. And of course, continuing our death penalty work. Our death penalty work, apart from some in-depth research that we do, we are also heavily involved in representing prisoners on death row and do quite a fair bit of that work in the Supreme Court and increasingly in the high courts. And in that context, we worked with Rebecca quite a bit. And thank you for that, Rebecca, for the time and the effort that has gone into those cases. I know it's not easiest of cases to work on for a variety of reasons. So that's the context. And I'll start by requesting my colleague Nitika, as I said, who headed the sentencing project, to just give us the main findings of this from this report. Yeah, Nitika, over to you. Nitika, you're on mute.
You're on mute.
Hi, can you guys hear me now? Hi, good evening. My name is Neetika, and I'm going to be presenting the main findings from this study. And before I go on to do that, I want to quickly talk about the origin of this study, which comes from our foundational work, Death Penalty India Report, which was published in 2016, where when we studied the legal journey of all death sentences that are imposed at the trial court level, what we found was that in all cases between 2000 to 2015, only 4.9 of those 4.9% of those death sentences actually end up getting confirmed at the Supreme Court level. So the remaining either end up in acquittal or commutation. This got us really interested in trial courts as a site to understand why they were imposing death sentence so frequently, especially when so many decisions were getting overturned. So for this particular study, we analyzed all death sentences imposed by trial courts of Delhi, Madhya Pradesh, and Maharashtra between 2000 and 2015 over a 16-year period. And we chose these three states because death penalty was frequently imposed in these states, and even a large number of decisions were overturned at the appellate level. So the data set for this study comprised 215 judgments, which included 43 judgments from Delhi, 82 from Madhya Pradesh, and 90 from Maharashtra. While this study began with us trying to understand the compliance in the trial courts with the sentencing framework, which was originally developed in Bachan, Singh in 1980, in the process of engaging with these judgments, we also started understanding the impact of the normative and procedural gaps within Bachan Singh on trial courts. Much of the attention of death penalty scholarship has been on this erroneous application of death penalty sentencing framework, which is certainly a concern, but there's not been sufficient attention to the gaps within Bachan Singh itself, which is why a significant part of the report, apart from looking at the data from trial courts, also looks at the doctrinal critique to understand how Bachan Singh itself has contributed to the errors that we've seen in the last 40 years. Now, moving on to some of the quantitative findings from the trial courts, Section 235(2) of CRPC provides a bifurcated trial where the conviction and sentencing are meant to be separate proceedings. And in asking for and imposing the death sentence, Bachan Singh provides a framework for conducting sentencing hearings. Now, the lack of significance of sentencing hearings was very evident in trial courts, especially from the fact that in 44% cases, accused persons were sentenced to death on the day of conviction. The crisis was most acute in Madhya Pradesh, where same-day sentencing was observed in 77% of the cases. Maharashtra had sentencing on the same day in 34.4% of the cases, but 57% of the cases had sentencing with just a 24-hour gap. Delhi fared better relatively, with 53.4% of sentencing hearings taking place at least 1 week after the conviction. We also found that the trial courts had an extremely crime-centric understanding of the Bachan Singh framework, with little regard for mitigating circumstances. So contrary to Bachan Singh, which states that the concept and scope of mitigating factors must receive liberal and expansive construction, trial courts did not consider mitigating circumstances in 51% of the cases. And even in the cases that they were considered, the judgments revealed an understanding of mitigating circumstances as justification for the crime, rather than assigning blameworthiness or culpability. Now, reformation has been identified as a crucial mitigating factor in Bachan Singh, where the court actually went a step ahead to impose a burden on the state to show that the accused is beyond the probability of reformation. However, the findings from trial court judgments across these three states show that probability of reformation is hardly ever considered. And even when it is incorrectly tied to the brutality of the crime. In 71% cases, trial courts sentence persons to death without considering the probability of reformation. The Bachan-Singh sentencing framework reflects the shift in the legislative position which came in through the amendments to the CRPC in 1973 and the introduction of Section 354(3), which makes life imprisonment the default punishment and death penalty is an exceptional punishment which requires special reasons. Now, in interpreting special reasons, Bachan-Singh said that death sentence can only be imposed in the rarest of rare cases when the alternative option is unquestionably foreclosed. Contrary to this fundamental principle, in as many as 73.4% cases, trial courts did not consider the question of life imprisonment. And even in the small number of cases that it did, much like reformation, this was also dismissed as on the basis of brutality of the crime. It was very interesting to observe that the Supreme Court judgment in Machi is used far more frequently than Bachan-Singh by trial courts. Machi's possible incompatibility with Bachan-Singh hasn't received enough judicial or academic attention. And specific points of concern within Machi are the introduction of the 5 crime-centric categories that warrant the imposition of death sentence, the introduction of collective conscience as a sentencing factor, and the introduction of a standard of inadequacy for consideration of life imprisonment. And the report notes Machi's incompatibility with Bachan-Singh. We found that trial courts showed literal adherence to Machi's crime categories to impose the death sentence, giving a complete go-by to mitigating circumstances and the question of life imprisonment. And in other cases, we found the trial courts adopt a balance sheet approach to numerically balance out the mitigating circumstances rather than weighing them as mandated by Bachan-Singh. In the small number of cases where life imprisonment was considered by the trial courts in these 215 judgments, we found that most of these cases actually applied the lower standard of inadequacy that Machi has set out, which is foregrounded in the circumstances of crime, rather than abiding by the standard of unquestionably foreclosing life imprisonment. Collective conscience, which is a factor alien to Bachan-Singh, was frequently invoked to the complete exclusion of mitigating factors. And in 52% cases, which is 112 cases, it was used as a relevant factor in deciding the appropriate punishment. And of these 112 cases, in 63 cases, which is 56% cases, the courts considered absolutely no mitigating circumstances. The report also undertakes a doctrinal critique of the use of precedents in death penalty sentencing. We observed that precedents were used by trial courts almost as a replacement of the sentencing exercise. And chapter 3 of the report has a detailed discussion on this confusion, and it also talks about the appropriate role of precedents. We found the precedents being used in 2 problematic ways. One was for dismissal of mitigating factors as done in the precedents, and 2, to replicate the outcome, to replicate the sentence. And what we argue is that such reliance is in defiance of the spirit of individualized justice, which is envisaged under Section 235(2) of CRPC, because it conveys equality of outcome in similar cases as equality at the sentencing stage. And we problematize such understanding of equality because it's the equality of processes that is needed. And we argue that this can only be achieved if the normative and procedural gaps in Bachan-Singh are addressed. And coming to the last finding, what we also found was that another factor that was commonly invoked by trial courts while imposing the death sentence was phenological factors. Now, Bachan-Singh has drawn a distinction between retributive justice, which is based on just deserts, and retribution, which is vengeance or lex talionis. However, the use of factors like collective conscience, society's cry for justice, they made sentencing completely crime-centric, and it completely negated the idea of individualized sentencing. Mitigating factors were almost never considered when the trial courts sought to punish the accused persons for committing a crime to satisfy society's cry for justice. Similarly, the theory of deterrence was used to send a message to the society that brutal crimes would not be tolerated, rather than a clear consideration of individual mitigating circumstances of the offender. So yes, these were the broader findings of the study. Thank you. Over to you, Anu.
Thanks, Nitika. Rebecca, do you want to just take a few minutes to give your comments on reading the report, what you thought, and then we can
Yes.
just after that get into the discussion and questions that I have. Yeah.
Right. So I think Nitika has pretty much said everything with respect to the structure of the report. I will, I'll just place this in perspective. I think it's very important for us to read the previous two reports that Project 39A has brought out. As Nitika rightly pointed out, the death penalty India report of 2016, where you interviewed about 373 death row prisoners and their families, and considered cases between 2000 and 2015. You looked at the trajectory of about 1,500 death sentence cases awarded by the trial courts and came to the conclusion that only 4.9% of the death sentences awarded by the trial court were eventually confirmed by the appellate courts. In fact, 65.3% of the cases ended in commutation and 29.8% ended in acquittal. So this is really an important report to understand the work you've subsequently done. In between, you brought out another report, which was again very interesting, Matters of Judgment, published in 2017, where you interviewed some 60 former judges of the Supreme Court and asked for their views on both the criminal justice system as well as death penalty. And it was fascinating to read that while a large majority of those judges believed that the criminal justice system in India was broken and that evidence was often fabricated, accused persons suffered from very, very poor representation, and all of this led to wrongful convictions. And yet they held on to the view that death penalty, they favored the awarding of death penalty, and they used all the aggravating factors to justify their position. Now, the present report, which is called Death Penalty Sentencing in Trial Courts, is important because this is where it all starts, and it's based sentencing in trial courts, as Nitika said, is usually done in a super fast manner based on an incorrect understanding of judgments of the Supreme Court, and this becomes the basis of errors that take place in superior courts. It's interesting. You've examined 215 judgments across 3 states. I was astonished to know that many of the death sentences were given by the state where I practice. I would have imagined that trial courts were better equipped and lawyers had a better understanding of the subject, but obviously they don't. And a large majority of the cases came from Delhi. Now, while you have, in a sense, critiqued the Bachan framework, you have also tried to understand why trial courts go wrong. And in a large majority of cases, you found out that there has been very, very poor legal representation. You've talked of same-day sentencing, which is very, very problematic. You've talked about this magic catchphrase called collective conscience, which is used to impose the death penalty, and how certain factors can suddenly become aggravating and suddenly become mitigating. It's interesting, and I like to quote from the report at page 28, where you talk of young age or the age of the victim and age of the accused. And at some point you've said, you've quoted from a judgment, I think it's Charan Lal's judgment, where, and I quote, "Can any mitigating circumstance be a reason for such a beastly act? Can such a person gain mercy and sympathy from society? Can such a person have repentance for his deeds and reform for the good? Should the court allow such a person to live a grand life after serving the punishment?" Now, so here, I mean, it's one thing that you consider the age of the accused, the young age of the accused, and decide after considering the aggravating and mitigating circumstances that the aggravating circumstances outweigh the young age of the accused in a case. But if you were to just disregard it in this fashion, then the weighing in hasn't taken place. And at the same time, when you look at the old age of the accused, you've given another instance where you say that in cases where old age was argued as a mitigating factor, it was dismissed by the court, saying that since the accused was old, there was little or no scope for reformation. So I find, some of these very the manner in which these factors have been considered, I find this completely amazing. Again, when courts have been given evidence that the accused is suffering from diseases like tuberculosis, the court has found that to be an irrelevant factor for purposes of commuting the sentence. Aside from this, I think what your report also focuses on is this complete lack of understanding of what is the law. I don't think any court knows that, and I don't think legal practitioners know it either. So the best we have at the moment is Bachan Singh with all its faults, and yet the Supreme Court itself is guilty of not following Bachan Singh in case after case. 3 years after Bachan Singh, you had Machi Singh, which did a 360-degree turn. And Machi Singh is found to be the appealing judgment and not Bachan Singh, although Bachan Singh is a constitution bench judgment. So you had judgments in the 90s, for example, in 97, Ravji versus State of Rajasthan, which only focused on the crime and not any other factors relating to the criminal, and upheld the death penalty. And some 13 years later, it was in 2009, I think, when all of these judgments were considered in Santosh Bariyar's case, that they were found to be per incurium. So 16 years after Bachan Singh, you have an execution taking place in 1996. Ravji Rao was actually executed in May 96. After him, following that judgment, Surja Ram was executed in April 1997, based on a judgment which was declared to be per incurium in 2009. But notwithstanding that, even today, courts would like to read, cite and read Ravji. I recall in the sentencing hearings in the Maruti case, I was summoned because I was told that they are asking for death. And one of the judgments cited was Ravji's case. And it shocked me that it was cited with great elan by the prosecutor as well as a senior counsel appearing for the complainant. And it was an overruled judgment. It was brought to the notice of the court. Mercifully, the court did not grant death, but granted life imprisonment. So the use of judgments which have either been overruled or which are not in consonance with the Constitution bench judgment is another problem which you have highlighted in the report. Even with respect to Bachan Singh, we tend to hang on to the catchphrase rarest of rare, whereas I think typically Bachan talks of the option of life being unquestionably foreclosed, which has to be linked, therefore, with the reformative process, which was highlighted in Bariyar's case. The balance sheet approach, which you've talked about, which was adopted in Machi, where you tabulate everything and present it as an accounting sheet. Again, Sangeet was the state of Haryana. It completely disapproved of that and said that you cannot balance aggravating and mitigating circumstances in this form, and essentially you're comparing apples with oranges. I think that's what they said in that report, in that judgment. So the big takeaways are really the fact that, before I come to the takeaways, I think the one thing that I was reminded of when I read this report was a judgment of Justice Krishna Iyer way back in 1977. It was compulsory reading for us when we were young juniors in our offices. G. Narasimhalulu's case, a 1977 Supreme Court judgment, where Justice Krishna Iyer, while talking about bail, said something very interesting. He said that questions like bail or jail at the pretrial stage belong to the blurred space of the criminal justice system and largely hinged on the hunch of the bench, otherwise called judicial discretion. So I think this paragraph can be used even with respect to death sentence sentencing, because it is really the hunch of the bench, and there are no guidelines, there are no good practices which courts should have laid down, which should be compulsory for in the sentencing process. And that really is the framework of this report. So I think what you've brought out is the fact that there is no institutional coherence, and that lack of institutional coherence has resulted in this complete mess, where you have even the Supreme Court contradicting itself during the same time period. And we are seeing that of late. We had a lot of cases which you were doing, where courts benches were commuting death to life, but we went to some other bench and Bachan got thrown out, and so it is, as Krishna Iyer says, the hunch of the bench, and that's actually brought out quite well in this report. I think I can leave the rest for the conversation I'll have with you.
Right. Thank you. Thank you, Rebecca, for that. And there are many points in there in both what you spoke about and what Neetika spoke about that I want to explore through the course of our conversation. But before I get into the death penalty specifics, I want to start more generally about criminal law as such, right? And the state of criminal law jurisprudence in the country over the last few decades. That yes, there is much confusion in death penalty sentencing law. We no longer know what the rarest of the rare is.
Yeah.
But is that true of larger criminal law jurisprudence as well? I mean, is that both in terms of its lack of clarity and the quality of it, right? If you could just speak to that briefly, and then we can build from there. Yeah.
Yes. So this confusion is consistent. You know, I mean, it's more stark. It makes more compelling reading when you're dealing with a life or death case, but it's consistent across the board because essentially we don't have a sentencing policy. And sentencing is that loose part of a criminal case where lawyers sometimes go, very often don't go, and have these 3 or 4 standard things which they say, and it's ultimately the same judge who's looked at the evidence, decided before he comes into court what he wants to do with the accused. Also, the problem arises because in many penal sections, you have this wide range, of punishments that a judge can pick up from. For example, 124A is punished with imprisonment for life, to which fine may be added, imprisonment which may extend to 3 years, to which fine may be added, or with fine. So you have life, 3 years, or fine. Now, what kind of sentencing guideline are you giving the trial judge? What is he going to base his judgment on, the sentencing judgment on? And this you see again and again and again in many cases. 195A, imprisonment for a term which may extend to 7 years, or with fine, or with both. And I have this whole list where, there's this very, very broad framework within which a judge can. So it is, as Krishna Iyer said, it is the hunch of the bench. You can get life, you can get 7 years, you can be let off on fine, and there is really no reason why you've gotten away with a lesser sentence, or you have got a higher sentence,
right.
And that's not apparent from any of the sentencing judgments either.
Yeah. I once heard Mr. Basant, who's the senior advocate in the Supreme Court, put it very well at the National Judicial Academy. So he asked the trial court judges there, okay, if you have a provision which says you can punish somebody up to 20 years, right? Where does the judge start? Does the judge start at 0 and build up with aggravating factors? Or does the judge start at 20 and then come down based on mitigating factors? Or do you start at 10 and move higher or lower, right? So there is, as you rightly said, there's no guidance coming from beyond. Yeah,
Absolutely. There's absolutely no guidance. And when when the judge wants to let you off on a lower sentence, he sometimes influenced by factors which are completely bizarre. So either way, there is no guidance. And after all these years, I don't know why we haven't corrected that.
So obviously there is that context of lack of legislative guidance within the statute books as well. And what then does happen is that there is this further judicial confusion that is then introduced into that lack of legislative clarity. And how does that impact trial court judges? Then you have a Supreme Court, you have a whole range of Supreme Court judgments that judges could choose from, completely dependent on what you call, as Krishna called, the hunch of the bench, right? There is a complete set of options for you. So what does this confusion do to courts below?
See, I go with the assumption that sometimes courts just don't know the law, and you have to tell them what the law is. Unfortunately, people on my side also don't fulfill their duties. Particularly where you have high sentences. I think, as I said, sentencing hearings are taken as just formalities. You go there, come back, hope for the best, and that kind of thing. No effort is made to bring out points which might help the judge lower the sentence. Now, in cases with life or death, you really have to ensure that you come within at least the Bachan Singh framework or whatever else that is followed subsequently. Unfortunately, if the lawyer himself doesn't know that Machi Singh is doing violence to Bachi Singh, that Ravji has been overruled, that Baryar and Sangeet and Shatrughan Chauhan and Kehar Singh give you a bunch of rights, but you're not aware of it and you don't bring it to the notice of the court, you end up getting this kind of mishmash sentence, which is why I think there is need to now bring more institutional coherence into this whole exercise. While sentencing generally is problematic, but I think in this space particularly, assuming that Bachan is the best law we have at the moment with all its problems, it still requires you to look at mitigating circumstances and aggravating circumstances, and you can't just you have to weigh them, and there was one exercise which was done in the Delhi High Court in Bharat Kumar's case by Justice Gupta and Justice Murlidhar, where they asked for the probationary officer's report, and came to the conclusion that the man could be reformed. There was nothing to suggest that he could not be reformed. Now, I believe these should be compulsory evidentiary hearings. I believe it's not sufficient to just argue these points. I think if you lay out a structure, you should leave evidence. The court can call witnesses. It could be medical evidence. It could be psychiatric evidence. It could be evidence of good conduct, many other things. But I believe there should be some kind of, maybe not a full hearing, but some kind of mini evidentiary hearing is important.
I think just that. Sorry, please go.
Yeah, and I don't know why it hasn't been done so far. So it was Justice Murlidhar opened the door for it, and very successfully, and commuted the sentence. But we could even go further than that, and do mini hearings. See, if you recall, in a case that you'd asked me to appear for you in the Supreme Court, it was a Chhattisgarh matter in which it has been confirmed, the death sentence has been confirmed. Now, the fact that these people were so poorly represented in the trial court, and very, very obvious pieces of evidence was not contested, fabricated pieces of evidence was not contested. Surely the Supreme Court or the appellate court, first appellate court, should be disturbed by that. It is apparent. You don't even have to argue it that there has been fabrication. I can say that because I looked at that case file in detail, and yet no questions were asked. So while there is onus on the defense lawyer to do his or her job properly, I also think there should be some kind of monitoring, if not by the trial court, but at least by the first appellate court, and certainly by the Supreme Court. What kind of representation did these people get? Or is it that we are happy that in these tough cases, the representation is poor, and so we can live with that? I don't know. I mean, sometimes when they see robust representation in unpopular cases, I think courts are sometimes taken aback and may not approve of it fully. So we're all quite, the impression I get is that obvious errors in trial, very obvious fabrications gone unnoticed, but neither the first appellate court nor the Supreme Court looks at it and considers it as a as miscarriage of justice, and says, your problem, you should have cross-examined, you didn't, how can you introduce evidence at this stage? And uses that to not only uphold the conviction, but also uphold the penalty. So I think in a country like India, where you've at least in a state like Delhi, you could still say that the representation is somewhat adequate, not always, but in other parts of the country, where representation is so woefully inadequate sometimes, and very technical things, especially now with the increased use of forensic evidence, DNA evidence, call data records, nodal officers evidence, etc., etc. A lot of things can be actually challenged, but not done in the trial court. And since we stick to this thing that we will not introduce any other evidence in the appellate court or in the super appellate court, there is no scope for correction. And that really is the story of death penalty cases in this country, because who are the people who are getting deaths? These are not people who can afford representation. These are people who are really very poor and cannot afford representation, and their representation is so bad that in the end, these are the cases which end in the.
I just wanted to narrate that story of the Chhattisgarh case that you were referring to, and that you appeared for us, and through that bring in a larger point on trial court advocacy in these cases at the trials at the conviction stage. And I just want to narrate that story. It's a very interesting case of a couple being sentenced to death for human sacrifice, right? And one of those cases, one of those victims in those cases, there is a question of whose body was that, right? There's a skeleton that's found in their backyard, right? And the question was, when we looked at the case, first there was this DNA report from a lab in Madhya Pradesh, which said that it is a match with the parents. The parents had reported the girl missing, and they said, oh, the skeleton is a match and it's a blood relative or whatever of the parents, right? And what we figured through looking at the case papers and then filing a RTI was that the prosecution had suppressed a prior DNA inquiry, which they had sent to a lab in Hyderabad. And that lab had replied saying that this
there was not sufficient material to do the test.
Not sufficient DNA material that to do the test and come to any conclusion of whether this child is the child of those parents or not. And therefore, nobody knew you couldn't say what that, unfortunately, this was figured out only in the Supreme Court. And it was, and the conviction based on this, of this girl, is then used as an aggravating factor to give them death in the subsequent case, right? And therefore, the struggle in the Supreme Court, as you well, because you argued it, was to say, why is this coming in now, right? I mean, why didn't you raise it? And it's it was really mind-boggling at that stage to say, okay, here you're talking of people who cannot afford a Rebecca John in Chhattisgarh, right? Right? Or in terms of don't have access, right? And therefore the question I had, Rebecca, was how much of this are errors committed during the conviction proceeding, given the quality of lawyering? And it's not just legal aid. Our data shows that most death row prisoners at the trial court level do access private lawyers, right? Of course, they get themselves more into debt and whatever it is, right? And they start relying on legal aid lawyers only in the appeal stages. How much of it is, given the nature of these cases, they're so high profile locally, we all might not read about it in our newspapers and see it on our television channels, unlike the Delhi gang rape case. But there is immense local pressure in these cases, right?
Yes.
But how much of these errors that trial court lawyers don't fix in the lower courts then come back to haunt them during sentencing and also subsequent appellate proceedings? And in that sense, a larger question on death penalty litigation strategy as to whether interventions then come in too late, right? That's the question.
Yes, there's I mean, the problem lies in the quality of representation in the trial court. I've always said are the toughest parts of a trial is the toughest part of a criminal case. Everything else is much easier. It's easier to argue from a record. It's easier to, in any case, how much are you, what kind of an audience do you receive in the Supreme Court? But the toughest part is to lay the structure of the case, the foundations of the case in the trial court. And if you need to do a good, robust trial, you should have an end in mind. You should know which witness is going where, what kind of evidence needs to be contested. You should have a fairly now good understanding of these big words they throw at you, DNA, this, that, and the other. And most lawyers are not equipped with it. Let's say they're still, even lawyers in bigger cities are still learning a lot of this stuff. What is allele, et cetera, et cetera. This whole DNA thing sounds very, very complex. Lawyers have just about gotten used to cross-examining post-mortem doctors. That too, most of the time, the cross-examination is nil. But all of this technical stuff, which is thrown in DNA reports, goes unchallenged, and for a large majority of us, it's unknown territory. So that is one. But even the nuts and bolts of criminal practice, where you confront a witness with his or her previous statement, and sometimes so much depends on that confrontation. Something you have not said earlier, you're introducing now, or you've said earlier and you are not saying it now because it goes in favor of an accused person. Confrontations don't happen. Even effective suggestions, which are important to tie up a case, is not given. So yes, I think the problem is with the foundation. I think in most of these cases, those people who are on death row receive a very, very poor representation. There is not even an attempt made to distinguish, if there are multiple accused persons, to distinguish the role of one accused from the roles of other accused persons. And so, it's possible in a given case, and as a matter of strategy, we insist that even if there are 4 members of a family, have different lawyers, because at least you can pull your case out from the rest of the pack, and whoever can succeed should succeed. But these things are not. It's very important to focus on your role, and you might be convicted. For example, in the December 16 case, one of the persons was driving a bus. Now, it should have been argued consistently that maybe there was evidence to convict him under 120B, but surely it wasn't a case of death, right? Because there wasn't the kind of evidence which was available with respect to the other accused persons. But I think those things are lost, and it was never done in the trial court. I was surprised it wasn't done in the High Court or in the Supreme Court, and therefore there is no attempt to individualized. We talk of the sentencing process being an individualized process, but even on merits, there is no attempt made to isolate the role of one from the other. So yes, there are many problems with the way trial court lawyers conduct trials in these cases. Largely poor people, largely people where apparently the facts look horrific, and so no one wants to touch them. And in the end, it's just an in and out appearance, and the client pays the price for your shoddy work.
I do have a whole range of questions on the Delhi gang rape case, and I will come to them. But before that, one last aspect of this bridge between the conviction case and the sentencing case is this strange concept that has been developed in the Supreme Court, on residual doubt as a sentencing factor, right? Where judges are saying, okay, there is some residual doubt in the conviction case that we can see, but that residual doubt in conviction is not sufficient to get you an acquittal. We will acquit you with that residual doubt. We will convict you with that residual doubt, but we will then use that residual doubt as a sentencing factor, right? What do you think is happening there? Is it that judges are, I mean, yeah.
I wish I had an answer to that. I haven't understood what is happening. So, I mean, essentially, the fundamentals of criminal jurisprudence is if there is doubt, it must benefit the accused. And you're saying there is some, there is some residual doubt. So, but we're not using it to convict you. We're not using it to acquit you, but we'll use it to sentence you. It's a strange. I really haven't understood the logic of that. It's very, very strange, and it essentially I have noticed in most of these cases. Once they've made up their mind that this is not a case where they will interfere, they will keep throwing these catchphrases at you, and no matter what you say. So even in the case of this Chhattisgarh couple, there was the bench was convinced that with respect to the skeleton of the girl, there was questionable evidence. They were convinced about it. But turned around and said, but some skeleton was found in your backyard, It may not be this girl, but the fact is that you have prosecuted this couple for the murder of two named people, two named children. And if it's not this girl, then the prosecution has failed in its principal duty of establishing that couple A and B killed child Y. This is a very convoluted logic. It's very difficult to understand that.
So I just want to use this moment to now transition into some some questions around the Delhi gang rape case. Of course, in the final stages of that case, we saw some excellent lawyering from advocates Vrinda Grover, from you, and advocate Anjana Prakash, right? And I think that brought out of so many aspects of that case that didn't end up receiving the kind of attention that it did. And the reason why I want to talk about that is, if at all there is this great example of brutality of crime, finishing off a case, right? Saying that in terms of everyone knowing that what is the done outcome in this case. And if ever there was a case that was entirely about the facts of the crime deciding the entire course of the case, be it the trial, the sentence, appeal, post-sentence litigation, mercy petition. And therefore, from that, the first question I want to ask, right, is related to how difficult is it becoming to be lawyers in such cases, right? Where you had lawyers like you, Vrinda, Anjana Prakash, standing up And I'm sure, and I think people who are listening in would want to know. And I thought it was fantastic that the best lawyering in this case came from three women, right? But surely there were. It was not as simple as it seemed about just standing up and going and arguing these cases. But and I want to place that in the context of lawyering per se, generally of unpopular cases, of being lawyers in unpopular cases more broadly. What are you seeing? And then what one reads and what one sees, it's becoming a very, very dangerous situation, right?
Yes, it is. We had. I can speak for my experience. It wasn't as broad as Vrinda's experience because she was there much before me and much after me. But it was a tough one. You know, I mean, when you read the judgment. In fact, as one of my colleagues said, when you read the postmortem report, you came out feeling very, very deeply conflicted. It wasn't an easy one, but it was also important to establish. You see, what was happening was that everything became tied up with political events, and at the time when I was asked to appear in the case, we were basically asking for very basic things. So a mercy petition had been filed. Shatrughan Chauhan says that after it was rejected, a period of 15 days time had to be given. So the death warrant was unexecutable. Yeah. There was a fair amount of backlash from the High Court. I've thought about it subsequently, and as something I said earlier in my address is that sometimes I think courts don't like such cases to be represented robustly at whichever stage, and they're quite happy with crazy representation. You know, I could sense from the body language of my court that they were not entirely approving the fact that I was appearing in the matter. But what was the relief we sought? I mean, we basically sought relief that was part of Supreme Court judgment, which was part of the jail manual, you know, yeah. And it was a given that you had to, so we had to fight for that. Yeah. And then when we went to the Supreme Court in a post-mercy challenge, what amazed me was also the fact that law, and there's reasonably good jurisprudence on that, was unknown to the Supreme Court. So the first question that was asked was, you know, how can we interfere with the decision of the president under Article 72? We are not sitting here to decide whether his decision was right or wrong. Whereas both Singh and Shatrughan Chauhan's judgment have paragraph after paragraph would say that you know, the president exercises his powers in a different jurisprudence. He has the right to review the entire case material, including the judgments of the trial court, High Court, and Supreme Court, and come to a decision which is separate from the courts. And in that, he's not acting as a super court. He's just functioning under his powers enshrined in Article 72. Yeah. Also, the materials that are sent with the mercy petition, how much time, how has he engaged with it, what has he done? Now, you know, it was sad because that kind of rich jurisprudence, you know how Supreme Court hearings are, you have to complete it within a specified time frame. It got lost. Firstly, it came as a surprise that they could look into the presidential action. And then, you know, a file was sent across to them and they looked at it and were satisfied that the president had looked at everything in a short period of time. So I think my takeaways are that one, you are unpopular while dealing with it. You're unpopular in the bar, where a lot of people come and ask you, why are you doing this case? You are not very popular with the bench, and the bench sits there. It's tragically not familiar with the jurisprudence, and when you tell them that you can look into this, there's a limited scope for judicial review. Inevitably, in this case at least, they didn't want to go down that route. So it was a difficult one. I think it was probably much more difficult for Vrinda, because she was dealing with all the three courts, and so it was emotionally very challenging. I think the reason why we did it, I think at the end of the day, we were trying to re-establish the fact that there are rights that even a death row convict has, and those rights are his. He can claim them. The Supreme Court says till the last breath of his life, and that was what we were trying to reinforce. All the Article 21 protections are available to a death row convict. It doesn't matter whether he's the worst criminal on earth. We were not challenging the merits of the case. That was over. That journey was over. But post mercy, there is a journey, and you needed to uphold those rights. To some extent, we succeeded. We got the 14-day period. We also succeeded in the fact that the state was trying to bifurcate the hangings. We didn't allow that to happen. We insisted that it was a common judgment, and therefore, if at all there was going to be a hanging, it was after each one of them had exhausted their processes, and it had to be a joint execution and not an isolated execution. So some of those rights were reinforced, but it was a tough journey. It was very tough. I don't think we had very many people on our side during that period.
And I think I remember during that hearing where I think on a Sunday where the government wanted to split the hearings or split the hangings, and that hearing where I thought very powerfully said that even people that are hated most by society have rights, right? And courts cannot be that populist institution. Their job is to apply the rights in the Constitution and apply the law. And while on in television studios and streets, people might have the view that, oh, let's not give them these rights. Courts just cannot have that attitude or approach. And one of the biggest pluses in that, I mean, I think amongst the very few pluses in that case was, I think, the incredible role played by the magistracy in Delhi, in the Patiala House courts, in all those death warrant hearings. It was so inspiring to see those.
Scrupulously followed the law.
Scrupulously,
and that was very, very inspiring. So while we're discussing trial courts and what and the errors trial courts make, I think the subordinate judge who was dealing with the warrant issue was quite amazing. I think he scrupulously followed the law. He was extremely patient, even when a lot of nonsense was happening in front of him, and that was quite incredible. With respect to the Sunday hearing, also, we didn't know which way it was going to go, but again, that was one of the few very, very positive hearings in this case, where eventually the judge agreed with us. He did give a judgment which said that there cannot be an isolated case of hanging. Everybody's rights have to be exhausted, and in fact went as far as giving an additional period of time, that if somebody has not fully exercised his remedies, then I'm giving you this extra 7 days to do it. So I thought that was a very compassionate judgment. It also, because ultimately this is a space where you have to be humane. I mean, post mercy or mercy to death warrant. That's a stage where somebody is looking to kill you, but you are trying to infuse humanity in the way you contest and argue in courts.
Yeah.
And I thought that was a very satisfying hearing. And all the hearings that took place in the trial court were quite amazing because of the scrupulous adherence to the law that the judge showed.
Yeah. No, I mean, it's interesting that, much of this is so much is flowing from Singh, and Singh was given what it was. It was assassination of a prime minister, Ram Jethmalani appearing for...
Jethmalani and Shanti Bhushan, two pillars of the criminal bar, appeared in that case, relating to the assassination of a prime minister. And at that time, I don't think there was any kind of noise about why are you appearing and all. So I think somewhere we've all changed in the way we look at these cases, and everything is, we are looking to add on offenses, we are looking to increase sentences, we are making more and more sentences punishable with death. So we've got into that space where these challenges will become very, very difficult as time goes move forward.
So one aspect of the Delhi gang rape case, and I just want to take it back to the sentencing conversation, is that if you look at the sentencing errors that were made, right? The Supreme Court acknowledges that the trial court and the High Court did not carry out sentencing properly. There was no individualized role attributed, that they're very, they clearly acknowledge it. It was too blatant that the Damakai, Santosh Hegde and Raju Ramchandran pointed out. But the court adopts this rather strange solution, and that's a gray area in the law, saying that there are sentencing errors. The sentencing has not happened properly, but we will cure it. It's instead of saying that proper sentencing needs to be heard by 3 levels of the judiciary, the court adopts the approach that we will resolve it, is one point. And second, a proper sentencing exercise would have told us so much about who these 4 people were, right? The noise in the television studios and the public might say, we don't care who they are, let's just hang them, let's not even have a trial like we saw in Hyderabad, right? That apart. I'm not on that. I'm just on the legal conversation. Just the quality of the sentencing information that was there was just so deficient, right? Even after the Supreme Court called for those
that was in the review petition.
It was in the, right?
It wasn't even in the, it was in the review petition. But even there, I mean, see, this is why I'm saying, I think if we all fail in this, we fail as practitioners, we fail as judges. So there's a complete failure. So even in the manner in which mitigating circumstances were presented, that it was truly deficient, as documents. And then the Supreme Court did exactly what the trial court and the High Court. It went through the exercise of looking at mitigating and aggravating circumstances, almost like the balance sheet approach in Machi. So it called for those affidavits, but didn't really consider them. And even from the point of view of the convicts, I don't think it was put across there were many mitigating circumstances which then became apparent in the various mercy petitions that were filed, because there was more individualized attention that was given, at least in the case in which I was appearing. It was a very, very painful but powerful document, the mercy petition.
And one wonders what would have happened if all of this was presented earlier.
Verifiable facts, and yet that was not brought across as mitigating circumstances in the sentencing hearing, although it took place in the Supreme Court. So I'm not even going into the issue of where it happened, the jurisdiction where it happened. But in the end, what does it say of all of us? I mean, it's easy to look at courts and it's easy to condemn judgments, but I think we are also culpable in the process, because we are not actually telling the story of our client. He may have, as I said, committed the worst crime, but he had a story to tell. And if looked at that story in perspective, as I said, the mercy petition was a very, very compelling read. It was very, very painful to read it. It might, in another world, have been sufficient to commute his sentence to life.
And I think one of the footnotes in the history of that case was that it was first initially heard by Justices Deepak Mishra, Gopal Gowda, and Justice Kurian Joseph. And I still distinctly remember one of the orders saying that it shall not be part heard.
Yes.
Right? And it just talks about it. Just if the story might have been very different if the case had stayed with that bench. And right, I don't know. I mean, I don't want to. I just want.
Period, Anu, in this, so while this happened, just before that, we had the magical case of Ankur Maruti Shinde's case, where the Supreme Court actually, in review, acknowledged all the errors it made on its own, and there were so many blooming errors in that case, and went about reassessing the evidence.
Yeah.
Came to the conclusion that these men were innocent. They were part of a nomadic tribe in Maharashtra,
Yeah.
that they were innocent, and then proceeded to award compensation for the 15 or 16 years of unlawful incarceration they were subjected to. So this was also happening, I mean, it's a funny space. The last judgment of Justice Kurian Joseph, again, where he talks about this whole issue which you've addressed in your report about equality, and he says, what are you calling for jail reports? And he this entire section is dedicated to manufactured jail reports. What do prisons allow prisoners to do? And again, it's so heavily weighed against the poor prisoner as against the rich prisoner. So while the December 16 rape case went the way it did, just preceding that or around that time, you had these other judgments which probably were not high profile, but had the same consequences. And courts gave two extremely inspiring judgments.
Yeah, it's in the last 2 years, right? It's very interesting to see, across how many the Supreme Court in the calendar years 2018 and 2019, they decided death sentences concerning 49 prisoners, right? And confirmed on 9, right? That confirmed 9 death sentences. And for me, that tells a story. I mean, for me, however, the story is not that, oh, look, it's working great that only 9 out of those 49 got the death sentence confirmed in the last 2 years. It tells me a story of, it really is a story of who those 9 went before, right?
That's right.
It's entirely a story of who those hunch of the bench. And, and as going forward in terms of what we can do, I had 2 questions, and I'll ask you the first one. One relates to something I read about you being amicus in a case in the Delhi High Court on practice directions or in terms of how victims of sexual assault who are living abroad, right? Who were sexually assaulted in India and are now living abroad, what should we do and how should we take those cases forward, right? And then the court is issuing practice directions. And is that I know, I mean, even those kind of process.
I'm glad you brought that up, Anu, because clearly trial courts need direction, right? And they need, these are specialized cases, they need training. And I think someone needs to put practice directions in place. Obviously, a superior court can't tell the trial court how to decide a particular case. But how to view mitigating circumstances, how to view aggravating circumstances, get out of this rarest of rare mold, look at reformation, look at whether the prisoner can be reformed, and then come to the conclusion that the option for life is unquestionably foreclosed, as Bachan Singh said. So I think the the time has come to do a little more detailing. And some practice directions are required, because in what we are seeing consistently, that however flawed the framework is, but even that framework is not being followed. And the prosecutor just comes up and says, "Oh, this is such a heinous crime, you have to convict him for death," and the defense lawyer says, and the other issue is the same day sentencing. These are serious errors that are being made. And therefore, I think in an appropriate case, we should insist on superior courts giving practice directions, on compulsory evidentiary hearing, on not having same-day sentences. I even have a view that in some, it's something that I've been thinking about. But if a judge has looked at the journey of a trial and obviously dealt with very problematic facts and has convicted a person, which is punishable with life or death, is it time to just think about whether the same judge should be sentencing the accused, or whether, for purposes of sentencing, you send the accused in the file to another court? I don't know. I'm not sure how this will work. I'm not even sure whether there'll be many takers for this. Yeah. But what I see in case after case is that the judge also carries his baggage of the facts of the case, and he just cannot disconnect from what he's seen in the trial when he's sentencing, and brings back some of those facts which are not sometimes required for sentencing. Doesn't bring facts which will help an accused, but brings back the facts which are very troubling, and uses that to sentence. So is it time? Because is it time? So bifurcation is one thing between conviction and sentence. Is it time that we have also bifurcation in terms of two different judicial officers looking at conviction and sentence? It's just a very
it's an interesting and challenging idea.
I don't know whether it will it will work. I have to still think through it, but I just feel that in all of these cases, and I can imagine a judge who's looked at the evidence in the Nirbhaya case, and then it's a foregone conclusion what he's going to do. Shouldn't a fresh mind look at it? Shouldn't you, limited to the purpose of sentencing? So when you are calling in, say, witnesses from the jail, or witnesses who will testify to your condition at home, if you have a previous medical history, if you're bringing in that evidence, somebody new is looking at it. He might reach the same conclusion, but I find this overlap between the convicting process and the sentencing process, particularly in crimes which have the death penalty, a little problematic.
I know we are running out of time, but I have two questions that I'd like you to comment on, and then we can sort of move on that. One is the recent spate of, as I said, just the numbers that I gave from the Supreme Court over the last 2 years. While, of course, the death sentence has been avoided in a large majority of those cases, it has come at the cost of very long prison sentences without remission and without parole, right? And sort of exclusion, sort of moving from the judgment in Sriharan, the Constitution Bench judgment in Sriharan, that the remission powers of the state government can be excluded. And that, I even wonder if it's something, even if it's even a victory when you say, 40 more years without remission, right? Or rest of natural life without remission. And I'm reluctant to view that as an acceptable cost for avoiding death sentences. And I just wanted your thoughts on that. That's one. And second, just to wrap up in terms of what do you see the future of, what should be the future of death penalty litigation? In the sense that I asked that because we see much of the intervention happening in the Supreme Court stage, so much intervention happening at the mercy petition stage, right? And now there is a certain predictability to the entire post-mercy litigation, right? In terms of there is an attack on Shatrughan Chauhan. You see the
Yes.
union
We saw
wanting
that.
to file, I don't know, I mean, just a very strange process adopted by the union to just change what it does not like. I mean, it's
I don't know. After how many years they wanted a review of the Supreme Court judgment and wanted to make it victim-centric. You know, this is all the cacophony that takes place outside, and the amount of time the television studios, spend on debating these issues. That good law, which people have worked very hard. Putting it together, suddenly, you have one petition saying all these guidelines are accused-centric, make it victim-centric. So
and it's a case even in which review has been already dealt with, dismissed, and I don't know on what grounds. I mean, it's really the strange.
I think even the curative happened in that case.
Yeah, right. It did. Yes. And then now there is a sudden, oh, we don't like this, so let's. But so what do you view as the way forward? Right?
Without remission is again very, very problematic, and increasingly judicial officers are resorting to sentencing people with that. So they say, okay, no death, you won there, but life without remission. And I find the routineness of the sentence quite amazing. I'm engaged in this matter in Punjab and Haryana High Court, where it's a case of zero evidence, but there's some noise around the case, social and political noise around the case, but zero evidence on record. And the sentencing order says life without remission. 12 or 13 people have been sentenced to life without remission. I find that actually very, very problematic. So it's not a this or that situation. I think both need to be challenged. And while we do our best to ensure that people who are on death row come out of death row, but this life without remission is not a substitute for that. However much we value life, I find that extremely problematic. It's a trend which has started. It's become very fashionable in courts now to sentence people to life without remission. It really, really needs to be taken up and challenged.
Yeah. And on the future of death penalty litigation, I mean, is it? I mean, are we better off trying to devise a strategy where interventions are made in the high courts? And
no, I think we see. I mean, if one has a chance, one should start at the original jurisdiction, and that's where mistakes are made. That's where everything can be corrected. That's where your best defense, and what the American Bar Association calls the integrated defense strategy is created at the trial court. And it's the robustness of the defense which will withstand scrutiny in the First Appellate Court and the Supreme Court. So while it's good to intervene in all of these courts, but I think there has to be more effective interventions at the trial court. Trials are is a complicated business. Trials are very, very difficult to conduct, and people tend to look at trial lawyers as if they just haven't made it in life, but they are actually the most important people in the hierarchy. And unless you've got your trial right, and unless you've framed it in this integrated fashion, the chances of, you can still get a wrong judgment, but then if your foundations are strong, I think as you go up, it will be easier for you to argue and to intervene. So I think interventions in the trial court is definitely a must.
Right.
I have I enjoy doing trial work. I firmly believed in the structure of a case, and unless that structure is in place, I think whatever appellate strategies you may adopt, it may succeed, it may not succeed. But without that structure, without that foundation, the case will not reach the conclusion you wanted to reach.
So Rebecca, while I traverse through the 82 questions that have come, I will and I'll have to pick a few from that. I will just request my colleague Preeti, who's also was an integral part of this trial court sentencing project, just to give her comments on the discussion and so that we can hear her viewpoints as well. Preeti, do you want to just go ahead while I just go through the questions?
Hi everyone. This is Preeti, and thank you so much, Anup and Rebecca, for that very important, crucial discussion. And as someone who's read these trial court judgments very closely with Neetika and Rahul, the discussion raised so many important points about death penalty sentencing generally, not just at the trial court level, but even at the High Court and the Supreme Court level. And Rebecca, as you said, truly, this particular sentencing report, it has to be looked at in the context of all the research that Project 39A has done so far. And for me, what remains a very crucial takeaway, which I hope the audience also takes from this discussion, is we found over nearly half a decade of research on the death penalty that while public opinion on the death penalty endorses it, thinking that it's imposed only in these very few brutal, rarest of rare cases, because that is what the Supreme Court intends. We found that there's actually really no singular understanding of rarest of rare. And that's true like at the trial court level, as we found in the report, but that's also true for the Supreme Court, which while interviewing 60 judges of the Supreme Court, former judges, that's what we found, that the rarest of rare is interpreted very, very arbitrarily, and depends on what the judges themselves feel about it. And if that is the situation of death penalty generally, I wonder if that should be an important factor when the public weighs in about the legitimacy of the death penalty as a punishment, whether that should weigh in as a factor, that it's actually not these very few brutal rarest of rare cases, but that no one knows what these rarest of rare cases are, and that's what makes it so unpredictable and arbitrary. And closely related to that, Rebecca, is your point on these tough cases. And I wonder what the role of tough cases should be in the criminal justice system. Should they be used to push the law further, like we saw in Singh, or should those cases become these scapegoats where judges and courts kind of give in to majoritarian populist opinions? And if that's what seems to be happening, if so many of us who are working closely with the criminal justice system feel that these cases where very unpopular defendants getting robust representation is something that makes courts unhappy, then what kind of a justice system are we moving towards? Are we just, is it that mob mentality has got a garb of sorts in the name of procedure? Or is there something more to it? Is it becoming increasingly tougher for courts and for judges based on social media, news, and the nature of media just generally? And finally, there's one point that I've been thinking about, and my colleagues who worked with me on the report have been thinking about, um, is how much of the blame really lies with the trial courts when on the question of sentencing material, when we see even the Supreme Court, like you mentioned in the December 16 case, the quality of sentencing material itself was uh, not the best, best that one can imagine. And if the Supreme Court doesn't feel that there's a problem with it, then what guidance does it really give to trial courts? And from where are they supposed to get these ideas of what an ideal sentencing hearing is? And like with that, I'd just like to conclude with the points that you raised about a separate evidentiary hearing and having a separate sentencing judge. And I wonder if like what steps we could take as stakeholders in the criminal justice system to move towards a system where sentencing also is given equal importance as conviction as part of the right to fair trial of an accused.
Thank you,
Thank you
Preeti.
so much. Yeah, and
Yeah,
we have
thanks.
many questions. So
Yeah, so I've gone through them, and Rebecca, I've just try to group them, and I'll just ask you that question. The first question was, one of the questions was, okay, and I think that's from Justice Lokur, if I'm not wrong, was what should the solution be to poor representation, right? Now, if a court does feel, right, I guess there is some question on what should the court consider as poor representation, right? And then what should the consequence be? Should it then send it back for trial, or should it just resolve that deficiency in process itself, right? Either before the High Court or before the Supreme Court, or should it acquit? What should be the solution? That's one question. The second question was on residual doubt. Shouldn't we accept it as being beneficial to the accused, that residual doubt is benefiting the accused from escaping the gallows in that sense, and therefore the residual doubt theory is beneficial to the accused is one. And the third set of questions centered around victims' rights, right? What about, and we saw that also play out quite strongly in the Delhi gang rape case. What about victims' rights? Is it in victims' interest to have harsher punishments? What they want, doesn't it matter? And how do we view victims' rights and its relationship with punishment? So these three broad questions. You're on mute, Rebecca. You're still on mute, I think. Yeah. I can't hear you. Rebecca, I think, can you just type it in the chat at the bottom of your screen? You should, yeah. Now you're unmuted.
Yeah, I think you had can you hear me now?
Yeah, I can hear you now. Yeah.
Okay, I think the host had muted me. Maybe
Okay.
I spoke too much.
Sorry.
All right. Okay. Now, the first question was just once more. The first set of questions was with respect to
poor representation.
Poor representation.
And what amounts to poor representation, and what should we do once we figure out that there is poor representation? Should we acquit? Should we send it back? Yeah.
Yeah. Well, if there's poor representation, and like I said in the Chhattisgarh case, the Supreme Court wasn't willing to look at it as poor representation, wasn't even willing to accept unimpeachable evidence in the form of RTI replies that your team had moved, which clearly showed that the evidence had been fabricated. So the fact that the Supreme Court was hesitant to A, look at that additional evidence, and B, look at it and come to the conclusion that the two accused persons were victims of very, very poor representation is problematic. Now, should you send it back would mean that the whole process has to start all over again. Well, in a given case, courts have done that. They have sent it back. The Delhi High Court, in fact, Justice Muralidhar at various points invoked in view of the fact that he was exercising appellate powers, his power to record additional evidence, and allowed some of those gaps to be filled up by allowing the plea of either side to record additional evidence. We use that in our favor in the Hashimpura case, where certain documents arguments had missed the attention of the prosecutor and was subsequently proved through this process. And then the file came back to the High Court, and the High Court used that, in fact, to convict the accused persons. Now, so these are different. I can't give a general answer. Should it be remanded back completely? It really depends. But courts, superior courts, even the trial court, should be troubled when they see poor representation. That is not happening. And on the contrary, there is an attempt to say, what a foolish lawyer, I didn't even ask basic questions. But I think like abroad, we should bring in rules where a court is not just looking at it from the point of view of what you've established on record, but what you could have established, questions that you should have asked but have not asked. And either warn the lawyer or ask the litigant whether he wants a better lawyer, etc. So I think this monitoring should take place at the trial court. And certainly if that hasn't happened, superior courts should be troubled by it. Should the entire case be remanded back? Really depends on depends on how much of it rests on the complete evidence or a portion of it. I would rather that if something like this is brought to the notice of the higher court. See, I'll give you another example. In one of the cases which we did, we were engaged at the very end, at the fag end of the trial, just for final arguments. And we noticed that certain basic confrontations, which actually affected the structure of the case, had not been done. We moved an application under 311, saying that, look, we've just been brought in to do it, but this has not been done. The trial court rejected the application. The High Court allowed the application. The Supreme Court reversed the High Court's order. So it was very obvious that those errors had happened because in that particular case, this was the Maruti trial. There were about 150 people on trial. There was one lawyer who was essentially handling everything. It was not possible for him to look at the case of each individual accused, and they were very poor people. You see, this is where I feel courts should allow. I mean, it's obvious that the story has changed. It's there in front of you. And yet you say, this is a delaying tactic. We are not going to interfere. The High Court accepted our plea, but the Supreme Court reversed it. So I think we should really be having a general jurisprudential conversation about what constitutes poor representation. Why are you so hesitant to allow reliefs like this? I think some of our appellate courts should shed their conservative approaches to these, especially when sentences are so high. It is possible in a long trial that something gets missed out. It needn't even be poor representation, but just oversight. Something has missed your attention. If an application under 311 is moved, allow it. Let the person get the best possible representation. That should be the position you're coming from.
Right.
That was the first question.
On the residual doubt, shouldn't it be viewed as being favorable to?
No, if you use doubt to acquit, I have no problems.
Yeah.
That is in fact the fundamental principle of criminal jurisprudence. But you can't bring, you are upholding the conviction, right? So, that's also a mishmash midway theory, which is really not acceptable, in the long run. It might work in a case or two, but if there is doubt, you have no business convicting. It is proof beyond reasonable doubt. Let's not forget the standards of a criminal case. And you coin these phrases called residual. What does it mean? I don't know.
Exactly.
No understanding of the word residual doubt. Either somebody has proved their case beyond reasonable doubt, or they haven't done it. You can't turn around and say they proved it, but there is still residual doubt. Well, if there's residual doubt, you have to acquit.
Acquit. Yeah. And the third question was victims' rights.
Yes.
What is and punishment?
I've appeared for victims. I've appeared for accused persons. But I think, particularly in the context, and we heard this a lot, especially when the union moved that petition asking for victim-centric writes saying that all the guidelines in Shatrughan Chauhan were accused-centric and were not victim-centric. Now, what were those guidelines? Those guidelines said that once a mercy petition was rejected, 15 days time should be given so that the accused makes peace with himself. He meets with his family. He finishes off his affairs. And if there is any residual challenge which is left, he's free to do it within that time frame. Why should that in any way be abandoned? And why is that viewed as accused-centric? What was the delay that was ultimate? I mean, eventually, a warrant which was first issued in January resulted in their execution in March, right? So you're looking at about 2 months. The period before that, which for which we were lambasted in different courts, nobody was interested in hurrying the process. The union parachuted at the end, but it wasn't interested in hastening the process before that. And if you look at the journey of that case from 2013 to 2020, it has crossed 3 stages: trial, High Court, Supreme Court, review, curative, mercy, post-mercy, and warrant. You know, I think it's a pretty decent pace considering that you don't finish a trial in that period of time. This was a day-to-day trial. The trial was over in less than 8 months. So I think there should be this proportionality of response. The Criminal Procedure Code is essentially giving rights and procedural rights to an accused person. And those must be upheld. Article 21 rights have to be upheld. The law laid down by the Supreme Court has to be upheld. You're taking a human being's life. So I found that a very strange argument at that stage, because as far as I'm concerned, if I was representing the victim, the minute the Supreme Court said convictions upheld, review dismissed, you proved your point. The person has been punished. He continues to remain in jail. These people would not have got out of jail. So are you equating a death sentence with victims' rights? I find that very problematic.
Yeah. Okay, so I think we're past 7 o'clock, and thank you so much, Rebecca. Not just for this fantastic discussion and being candid about so many things and forcing us to think deeply, but just the way you practice law and is extremely inspiring to so many of us. The manner in which you combine practice, academic thinking, and the kind of depth you bring to issues, it really is inspiring. And thank you so much for being that lawyer. And I'm sure many students watching, I hope many of them are inspired to take up criminal practice. And to all of you who are watching, I do hope that we all have that, especially as people interested in the law, that we resist that temptation that courts become forums of public opinion, right? That courts cannot become forums where public opinion is just imitated, right? Courts have a very clear counter-majoritarian function, and it just plays out the most in cases like the Delhi gang rape case. And that's where courts should be even more watchful, more guarded, that it's not that there aren't these different ways through which public opinion is creeping in. And one of the most profound articulations of that was in the South African Constitutional Court, when the constitutionality of the death penalty was being decided in Makwanyane. South African government brought forth some public opinion studies which showed massive support, public support for the death penalty. And the court, Justice Scalson's opinion, had only one thing to say. It said, we as a court are meant to implement the Constitution, to safeguard the Constitution. We are not here to give effect to public opinion, right? And that's just such a powerful way to imagine the role of a court in a constitutional democracy. And the death penalty and so many other issues bring that sharp edge of public opinion to the very doorstep of the courts. And we need to be very, very careful, not letting it in. Yeah. So on that note, thank you. Thank you everyone for tuning in, and thank you, Rebecca, once again for your time on the weekend. And I hope all of you have a good evening and that you're staying safe. Thank you,
very much. Thank you.
Thank you.
so
Thank you,
much.
and good night. Bye bye.